Okay, so I'm going to introduce some of the facts behind the cases we're going to talk about, just to give you a chance to look at them and form your own opinions about the substantial similarity analysis. So starting with Steinberg versus Columbia Pictures, I put on screen a so-called New Yorker's idea of the United States of America from 1937. So the idea of a comic map of a provincial view of the world, even a New Yorker's provincial view, is unprotectable. However, in Steinberg, the court says that since the defendants have conceded access, a somewhat lesser degree of similarity suffices to establish infringement than might otherwise be required. This is the dreaded inverse ratio rule, which confuses the two parts of the test, copying in fact and infringement. The Seventh Circuit and the Ninth Circuit have explicitly rejected this rule. Striking similarity under those circuits can itself be evidence of access, but evidence of access can't itself be evidence of substantial similarity, that is to say, infringing similarity. And that is the right rule, regardless of what the Steinberg court says. But as you can see, courts do not always agree on this. Another important rule illustrated by the case is that it does not matter that there are substantial original elements in the accused work. A copyright infringement may occur by reason of substantial similarity that involves only a small portion of each work. And this is the general rule. Again, you can compare this to the de minimis rule from last time. The de minimis rule puts a limit on how small the similarity can be, but there's no blanket rule, and adding lots of stuff will not protect you from infringement, except perhaps in certain special cases. So I want to show you other examples of the style at issue in the Steinberg case, and we can talk in class about which, if any of them, you might find infringing. So here's two images of the accused and accusing works. Here's a different promotional image. Another one. And consider how many of these take the same thing or perhaps different things from the original. Atlanta version. This is the new New Yorker version, post 9/11. Same artist doing the same thing with Washington. A law review publication. The Economist doing the same thing. Another cartoon. Oh, I thought I had one more, but I guess not. So I then do also want to introduce the case the Ninth Circuit uses as a foundation of its analysis, the Sid and Marty Krofft versus McDonald's case, which is often cited in future cases. So here we have the two mayors at issue in the case. I'm going to play a clip from the show and then an ad to show you some of the similarities. And now the McDonald's ad, or a McDonald's ad in the relevant campaign. So the Ninth Circuit gives us another two-part test. Similarity is divided into extrinsic and intrinsic. The first part Extrinsic similarity allows expert testimony about external factors like the demands of the medium, savoir-faire, perhaps something like whether it is a savoir-faire to hop or skip along with holding a child's hand, and so on. The second part does not allow expert testimony. The intrinsic part of the test, the jury has to react on its own. The Ninth Circuit's test takes the same basic two-step procedural approach as the second, admitting expert testimony on the factual question of copying, but not on the ultimate question of unlawful appropriation. Croft itself refers to the difference as being between similarity of ideas and similarity of expression, but that is neither the right question to ask nor the one the court actually asks in subsequent cases. It took the Ninth Circuit over a decade to realize that looking for similarity of ideas made no sense. And then they reinterpreted Croft to mean that the extrinsic test is a test for objective similarity, and the intrinsic test is a test for subjective similarity. And that gets us to the Cavalier versus Random House case involving Nikki Moonbeam. Believe it or not, one way to see this case is the Ninth Circuit attempting to tighten up its standard to allow more defendants to get summary judgment on similarities that come only from unprotectable elements, treating the extrinsic test as being about ideas only, rather than including at least some filtering of expression, which is what people had read the Croft test to do, allowed plaintiffs to avoid summary judgment way too often. So maybe after Cavalier, you can do some filtering of expression. The law is, though, the rule is, if there's a factual issue under the extrinsic test, the intrinsic test must be left for the jury. The defendant can only win summary judgment by showing that the only similarities come from unprotectable ideas, or that if anything, everything that you treat as expressive is included, there's still not substantial similarity. So in Cavalier, the court finds no protectable similarity in the simple plots. The plaintiff's rights, if any, will have to come from the images. In other cases, by the way, we see a similar idea that audiovisual characters may be more readily protectable than purely literary characters. We can recognize similarities more easily visually than textually. And this isn't necessarily articulated, but it does explain a lot of results. The court in Cavalier says, even though there isn't copying of the whole Nikki Moonbeam work, there's no character copying, the question remains whether protected parts of the Cavalier works have been copied. So here are the Cavalier works. Consider if they are what you think of as actual works as opposed to plans. But there they are side by side. Here are two images for which the court finds potential infringement. Here are two images that the court says no reasonable jury could find substantial similarity of protected expression in these. And in class, I'll ask if you agree. Before I leave you, I want to introduce a third test, which has already been mentioned in passing in some of the cases. For computer software in particular, most circuits have adopted Altai's abstraction filtration comparison approach. This has similarities to the extrinsic intrinsic division and may in fact just be an implementation of the extrinsic intrinsic division for works with very thin copyrights like software. So how this goes is a test showed up in Computer Associates International versus Altai. The court is supposed to figure out what the levels of abstraction are. So you start with the basic idea and then you work down to the specific components. The top level idea might be the idea of a word processing program. Then you divide the program's features into various functions and how they're organized. So proofreading is itself an unprotectable idea or abstraction. The court is then supposed to filter out after basically after the program has been diagrammed into relevant parts. The court is supposed to filter out non-protectable material from protectable expression. You examine the components that were ideas or that were for the public domain or were savoir-faire. So every word processing program probably needs a spell check. Then, and last, you compare what's left. Is there a so-called golden nugget? And could a fact finder find substantial similarity between the plaintiff's nugget and the defendant's nugget? And you can consider whether maybe we should be using that for every situation, not just software. That's it. I will see you in class.